even if Tucker Carlson had espoused the white replacement theory in the most malicious and racist form that it has, which is this one that the killer in Buffalo espoused, holding someone responsible for the violent acts of others based on the theory that their speech has somehow inspired those other people has long been regarded as taboo because it would destroy free speech. In every debate where there's an inflammatory or controversial sentiment, it is possible that you can go and inspire violence. As I said, Rachel Maddow sitting around year after year accusing Republicans of being white supremacists and Kremlin agents and traitors to the country, quite predictably inspired one of her viewers to go and attack and try and kill Republican members of Congress at a softball field in 2017. The idea that Rachel Maddow has blood on her hands because she expresses her political views that are protected by the Constitution, and that now somehow she's responsible because some nutcase in her audience decided to internalize that and go try and kill people, even though it was predictable that someone might. I mean, if you sit around saying the Republican Party are fascist and white supremacists and threats to the country, it's very predictable that someone in your audience might go and try and hurt a Republican. Nobody would say that her speech should be criminalized, even though she probably inspired this person to go and do that. Because in every debate, let's take the abortion debate. If you're somebody who was pro-life and says that you believe abortion is murder, of course you might inspire someone who hears you to go and kill an abortion doctor on the grounds that you convince them that abortion doctors are murderers. Conversely, if you argue that those who believe in an abortion ban are killing women by preventing them from getting procedures that might save their life, it is very predictable that you might inspire somebody to go bomb a pro-life clinic or pro-life office, as has happened several times in the past 2 years. The environmental activist who went and murdered that Dutch politician clearly was listening to radical environmentalists. But the minute you start trying to hold people responsible for the implications or the consequences of their political speech, immediately you make political speech impossible. Because every single person who has strong views on any topic runs the risk of inspiring others, even if it's not their intention, to go engage in violence carried out in the name of that cause. That is true of every single political faction and every single view and every single political debate. Now, there are two 20th century landmark Supreme Court cases that define the outer limits of free speech in a way that is extremely important to the protection of free speech in the United States. If you just look at the Bill of Rights, these are very short guarantees that the founders wrote on purpose, knowing that they were vague and that society would apply them in specifics as courts ended up ruling. The First Amendment is very short. It's one paragraph long, and there's no way to know all that much about what the First Amendment protects, what kinds of speech it protects, until you go and read Supreme Court cases and jurisprudence interpreting the First Amendment and setting those limits. And one of the most important cases is probably one with which you're familiar, which is the Brandenburg case in 1967, in which the state of Ohio tried to prosecute a leader of the Ku Klux Klan when the leader of the Ku Klux Klan stood up and said, "I believe our government is increasingly racist against white people, and if that doesn't stop, I think violence might become justifiable. We may have to take vengeance on them." And the state of Ohio tried to prosecute that KKK leader for that political speech on the grounds that he was advocating terrorism, namely the use of violence to achieve political ends. And the Supreme Court in Brandenburg ruled in 1967 that that conviction was unconstitutional. They overturned the conviction of that KKK leader. And they said that you're allowed to say anything in terms of political opinion that you want, including advocating the theoretical necessity of violence. That was how our country was founded, by people saying, I think the British king has become so repressive that a violent revolution is justifiable. And so the Supreme Court said, not only are you entitled to express every single political opinion, it even extends to the abstract expression of the need for violence. And they therefore overturned the prosecution of this KKK leader. And they created only one exception where your political speech can be prosecuted, which is if you are directing the imminent use of violence. So in other words, you gather a mob of people, all of whom are carrying gasoline and torches, and you say, I think we should go burn down that house right on that corner because it contains a senator who has done these bad things, and the mob then goes and does it. There you're deliberately inciting immediate and imminent violence. But other than that, even the expression of the need for political violence or the necessity of political violence is protected speech under the Constitution. Most people know that Brandenburg case. The case that is not as known and yet is at least as important is the one I want to talk to you about. Because this is the case that says that you cannot hold people liable for the behavior of others who hear your speech when that speech expresses constitutionally protected ideas. And this question is very relevant for the current attempt to try and indict Donald Trump for the speech he gave on January 6th on the theory that even though he didn't go to the Capitol and engage in violence or trespass, he inspired people to do so with the speech that he gave. And what's amazing about that is if you look at his speech, he specifically said, I don't want you to engage in violence. I want you to be peaceful. And yet liberals are eager. That's the kind of big prize for them, is to indict Trump, not on that documents case and not on the case of the bookkeeping errors in Manhattan, but they want to indict him as having inspired that quote unquote insurrection with the political speech he gave. And as I said, there's a similar case working its way through the court on the other side of the political aisle where a police officer who was beaten by Black Lives Matter protesters wants to hold responsible not only the people who beat him, but the Black Lives Matter leaders who gave the speech that he said inspires that violence. And in particular, the person that he wants to sue and hold responsible is DeRay McKeeson, the Black Lives Matter leader. And the case was originally dismissed, but now it was reinstated by an appeals court based on the theory that DeRay's speech can be said to have inspired these protesters. It's a very dangerous incursion, both of those, into free speech. So I want to show you what the Supreme Court said in the case of the NAACP versus Claiborne Hardware. It was a 1982 ruling. It was an 8-0 decision. The only person who did not vote was the Black Justice Thurgood Marshall. He recused himself because he had been general counsel for the NAACP during these events before going on the court. And what had happened in this case, which is incredibly interesting, I use this case a lot when I did First Amendment litigation, was that there were NAACP leaders who had imposed a boycott of white-owned stores in the state of Mississippi. And they would give these rousing speeches, angry, rousing speeches. And certain people who would hear these speeches would go and commit violence in the name of enforcing that boycott, including beating store owners or burning down stores. And they did a lot of property damage. And they sued these NAACP leaders, not the people engaged in the violence, but the leaders, on the theory that they had inspired these people to go and commit violence. And the state of Mississippi, in their court system, held a trial and found in favor of the plaintiffs and held these NAACP leaders liable. They appealed to the Supreme Court, and the Supreme Court overturned that verdict and said it is unconstitutional to hold people liable or responsible for the acts of others based on the theory that those other people were inspired by their political speech. So let me just show you some of the key parts of this decision. This is a crucial landmark decision that is now under attack in order to try and indict President Trump for his speech on January 6th, and that will in general let them set precedents that if your speech is too inflammatory, if it's too passionate, you can cross the line and somehow become a criminal because of the violence other people do in the names of the ideas that you defend. That's how dangerous this is. So here's what the court said, quote, "The boycott of white merchants at issue in this case took many forms. The boycott was launched at a meeting of a local branch of the NAACP attended by several hundred persons. Its acknowledged purpose was to secure compliance by both civic and business leaders with a lengthy list of demands for equality and racial justice. The boycott was supported by speeches and nonviolent picketing. Participants repeatedly encouraged others to join its cause. Each of these elements of the boycott is a form of speech or conduct that is ordinarily entitled to protection under the First and 14th Amendments. The black citizens named as defendants in this action banded together and collectively expressed their dissatisfaction with a social structure that had denied them rights to equal treatment and respect. And so as we recently acknowledged in the case of Citizens Against Rent Control versus Berkeley, quote, "The practice of persons sharing common views, banding together to achieve a common end is deeply embedded in the American political process. We recognize that, quote, by collective effect, individuals can make their views known when individually their voices would be faint or lost. In emphasizing, quote, the importance of freedom of association and guaranteeing the right of people to make their voices heard on public issues, we noted the words of Justice Harlan, writing for the court in NAACP versus Alabama, quote, effective advocacy of both public and private points of view, particularly controversial ones, is undeniably enhanced by group association, as this court has more than once recognized by remarking upon the close nexus between the freedoms of speech and assembly." The court then went on. The right to associate does not lose all constitutional protection merely because some members of the group may have participated in conduct or advocated doctrine that itself is not protected. In DeYoung versus Oregon, the court unanimously held that an individual could not be penalized simply for assisting in the conduct of an otherwise lawful meeting held under the auspices of the Communist Party, an organization that advocated, quote, criminal syndicalism. After reviewing the rights of citizens, quote, to meet peaceably for consultation in respect of public affairs and to petition for a redress of grievances, Chief Justice Hughes, writing for the court, stated, quote, it follows from these considerations that consistently with the federal constitution, peaceable assembly for a lawful discussion cannot be made a crime. Peaceable assembly for a lawful discussion cannot be made a crime. The holding of meetings for peaceable political actions cannot be prescribed. Those who assist in the conduct of such meetings cannot be branded as criminals on that score. Then the court went on to review a whole body of law that says that free speech protects not only just standing up and expressing ideas, but actually using those ideas to organize and to protest. And then this is what the court said, quote, in sum, the boycott by the NAACP in Mississippi clearly involved constitutionally protected activity. The established elements of speech, assembly, association, and petition, though not identical, are inseparable. Through exercise of these First Amendment rights, petitioners sought to bring about political, social, and economic change. The court acknowledged the First Amendment does not protect violence. Quote, certainly violence has no sanctuary in the First Amendment, and the use of weapons, gunpowders, and gasoline may not constitutionally masquerade under the guise of advocacy. Although the extent and significance of the violence in this case are vigorously disputed by the parties, there is no question that acts of violence occurred. They're saying people who engage in violence, even part of a political cause, are not protected under the First Amendment. And in this case, there's no question that people who are adherents to the NAACP use violence in order to advance this boycott. Nonetheless, the court ruled in favor of the defendants. And it said, quote, petitioners withheld their patronage from the white establishment of Claiborne County to challenge a political and economic system that had denied them the basic rights of dignity and equality that this country has fought a civil war to secure. While the state legitimately may impose damages for the consequences of violent conduct, it may not award compensation for the consequences of nonviolent protected activity. It may not award compensation for the consequences of nonviolent protected activity, meaning if you give a speech that itself is protected by the First Amendment because you're expressing politically protected ideas, you cannot be held legally responsible for the acts of others who carry out violence in its name. Quote, only those losses proximately caused by unlawful conduct can be recovered. The court went on. The First Amendment similarly restricts the ability of the state to impose liability on an individual solely because of his association with another. Meaning, if all you do is express your views, and it happens that the person next to you with whom you're working goes and commits violence, you cannot be held responsible for that person's acts. In Scales versus the United States, the court noted that a, quote, blanket prohibition of association with the group having both legal and illegal aims would present, quote, a real danger that legitimate political expression or association would be impaired. The court suggested that to punish association with such a group, there must be, quote, clear proof that a defendant specifically intends to accomplish the aim of the organization by resort to violence. That's the only way someone can be held legally responsible under the Constitution, is if they intend to use violence to accomplish their ends. The court went on. Moreover, in Noda versus the United States, the court emphasized that this intent must be judged, quote, according to the strictest law. For otherwise, there is a danger that one in sympathy with the legitimate aims of such an organization, but not specifically intend to accomplish them by resort to violence, might be punished for his adherence to lawful and constitutionally protected purposes because of other unprotected purposes which he does not necessarily share. In Healy versus James, the court applied these principles in a non-criminal context. In that case, the court held that a student group could not be denied recognition at a state-supported college merely because of its affiliation with a national organization associated with disruptive and violent campus activity. It noted that, quote, the court has consistently disapproved government action imposing criminal sanctions or denying rights and privileges solely because of a citizen's association with an unpopular organization. The court stated that, quote, it has been established that, quote, guilt by association alone, without establishing that an individual's association poses a threat feared by the government, is an impermissible basis upon which to deny First Amendment rights. Here's the key. Civil liability may not be imposed merely because an individual belonged to a group, some members of which committed acts of violence. Finally, the court said, quote, at the same time, the evidence does support the conclusion that some members of each of these NAACP groups engage in violence or threats of violence. Unquestionably, those individuals may be held responsible for the injuries that they caused. A judgment tailored to the consequences of their unlawful conduct may be sustained. We also rejected McKeeson's argument that imposing liability in these circumstances would violate the First Amendment. Okay, so that's the Claiborne case that essentially says that as long as what you're doing is protected by the First Amendment, then there's no way for you to be held criminally or legally responsible on the grounds that you somehow have inspired others to go and commit violence. If you're not directing them immediately to go commit violence, and if you're not yourself engaged in violence, you are completely protected by the First Amendment. And that has been a critical case, a critical part of 20th century jurisprudence, protecting our freedom of speech by ensuring that we cannot be criminally or legally blamed for the acts of others who hear our speeches and go commit violence. Now that Claiborne precedent has safeguarded our free speech rights in very crucial ways for many, many years. And now they're, like everything regarding free speech, is an attempt to erode it and to launch a full frontal attack on it. As I indicated, the most threatening development is the attempt to create a theory that would allow the Justice Department to criminalize the speech Donald Trump gave on January 6th. And we'll get to that in just a moment. But there is a case that produced a very alarming ruling just this week from the Fifth Court of Appeals, which is the case in which a police officer who was injured at a Black Lives Matter movement directed by DeRay McKesson, who was with Pod Save America and has kind of built a public profile for himself, was originally dismissed, and the Court of Appeals reinstated it. It went to the Supreme Court that ruled on a technicality and sent it back. And now the Court of Appeals has again decided not to dismiss this case, that instead there are circumstances, despite Claiborne, which the court says is its North Star, and it spends a lot of time discussing the parameters of Claiborne and its principles. Nonetheless, McKesson could be held liable even under Claiborne because Claiborne is now being weakened. There you see the case is Doe versus McKesson. They've given anonymity to the police officer who was injured, and the court explains why they're allowing this case to go forward and why it may go to trial and why McKesson could ultimately be held liable. And there you see the rationale on the screen. Quote, McKesson's actions were a necessary antecedent to Doe's injuries. Restated, Doe must prove that he would not have been injured but for the manner in which McKesson organized and led the protest. That is a tall task, and the standard will only be met in exceptional cases where, as here, The allegations support the inference that the leader's specific actions caused the plaintiff's injuries. To recap, where a defendant creates unreasonably dangerous conditions and where the creation of those conditions causes a plaintiff to sustain injuries, that defendant has, quote, directed his own, quote, tortious activities for purposes of Claiborne. Now, that really is a major inroad into Claiborne to say that even if you're somebody who's just leading a protest and if all you're doing is expressing views that inspire other people, you can still be held liable, in this case civilly, but presumably criminally, despite the principles enunciated in Claiborne that protect First Amendment activity from being criminalized by holding people accountable for the consequences, if you can prove that the person somehow acted negligently or created dangerous conditions that allowed someone to get injured. This is all part and parcel of the erosion of free speech protection and the increasing embrace by establishment actors of the idea that speech itself can be so dangerous that it has to be either outlawed or constricted or regulated, or the people responsible for having others hear their views can be criminally responsible or civilly responsible for those consequences. That, if that happens, will be one of the gravest threats to free speech in many years. Now, there was a dissent in this case, and I want to show you the key part because it reveals just why this is such a abandonment of longstanding First Amendment protection in this country. The dissent begins, quote, "I disagree that the plaintiff, the police officer, can sue McKesson as the protest leader. The Constitution that Officer Doe swore to protect itself protects McKesson's rights to speak, assemble, associate, and petition. First Amendment freedoms are not absolute, but there's the rub. Did McKesson stray from lawfully exercising his own rights to unlawfully exercising Doe's? I don't believe he did." And then they explain the Claiborne ruling that I just walked you through, and he said, quote, "Yet the Supreme Court unanimously held that the Constitution protected his, quote, highly charged political rhetoric, and it refused to hold him, quote, liable for the unlawful conduct of others." That's Claiborne. This, even though Evers, one of the people suing the NAACP leaders, vilified and urged, the NAACP leader, he's saying the court ruled in favor of the NAACP leaders, even though Evers, one of the NAACP leaders, vilified and urged violence against boycott breakers. Warning, quote, "If we catch any of you going in any of them racist stores, we're going to break your damn neck." Even that was protected free speech. The dissent says, quote, "Claiborne shows that, quote, mere advocacy of the use of force or violence does not remove speech from the protection of the First Amendment," citing Brandenburg. Because this NAACP leader only advocated for violence but did not provoke or incite imminent acts of violence, the court said his fiery words, quote, "did not exceed the bounds of protected speech." And under a wealth of precedent before and since, raucous political protests, even, quote, impassioned and emotionally charged appeals for the use of force are protected under the Constitution, unless intended to and likely to spark immediate violence. So while, quote, the state legitimately may impose damages for the consequences of violent conduct, it may not award compensation for the consequences of nonviolent protected activity. To sum up, state laws already protect protest leaders from liability for lawful conduct. For protest leaders, Claiborne and the First Amendment are nugatory unless they protect something that state law doesn't, namely conduct that is unlawful under state law. In other words, the only reason that Claiborne even matters, the only reason it exists, is because it's saying that state law cannot make certain behavior unlawful because doing so would violate the Constitution. Quote, "As to the specific question, whether a protest leader can be liable for someone else's violence, I view the protest leader's own violence as the dividing line between what the First Amendment does not protect." In other words, if the person being held responsible for violence did not himself engage in violence, that's the end of the inquiry because all he did was engage in protected First Amendment speech. This judge goes on, quote, "But even if that line fails, I believe that the protest leader's unlawful actions must at least be intentional. The majority's dividing line, lawful versus unlawful, yields the same result whether a defendant looks to state law or the Constitution. It says that the First Amendment protects protest leaders only until they need its help. This police officer put himself in harm's way to protect his community, including the violent protester who injured him. and states have undeniable authority to punish protest leaders and participants who themselves commit violence. The rock hurler's personal liability is obvious, but I do not believe that DeRay McKesson's is. Our Constitution explicitly protests nonviolent political protest. Claiborne is among, quote, our most significant First Amendment cases. It insulates nonviolent protesters from liability for others' conduct when engaging in political expression, even negligently planning a protest that aims to spur anything less than immediate violence. The Constitution does not insulate violence, but it does insulate citizens, including protest leaders, from responsibility for others' violence. Dr. Martin Luther King's last protest march was in March of 1968 in support of striking Memphis sanitation workers. It was a prelude to his assassination a week later, the day after his, quote, I've been to the mountaintop speech. Dr. King's hallmark was nonviolent protest, but as he led marchers down Beale Street, some young men began breaking storefront windows. The police moved in and violence erupted, harming peaceful demonstrators and youthful looters alike. Had Dr. King been sued, either by injured police or injured protesters, I cannot fathom that the Constitution he praised is, quote, magnificent, quote, a promissory note to which every American was to fall heir, would countenance his personal liability. That is what is at stake in upholding the principles of Claiborne, namely the right to free speech, which will be destroyed if you can be said to be held liable for the violent acts of others. Now, thanks for watching this clip from System Update. Catch our full shows for free, live weekdays at 7 p.m. Eastern on Rumble, and join our locals community at greenwald.locals.com for all of my written journalism, exclusive after-show Q&As, and more.